chair and they can show you where they're going to there.
Yes, sir.
You can take your seat, please. Is it just like that one now?
Yeah.
Since our neighbor likes to play. That would be a more appropriate.
Judge Matthews, Palos, thank you, Palos. You, if you look at those, 1027 and 2356, do you recognize this to be the small number column tie chancel? Correct. Okay. And so the times are 2356, 1208, 1208, 1209, 1209, 1210, 1210, 1215, 1215. And that's the long haul. Okay, so we got one call 1208, looks like. And that's times 1660, 2852.
Correct.
Okay, and that's the latest one. Long tie, the 310, 2168. I'm only worried about the times.
Okay.
Yeah, so that's from. No. I'm just asking about times that you can write down the time of the telephone calls.
So you're gonna ask for the highlighter?
Yeah. And I can put it, I'll put it up on the thing as demonstrated. I'll put it up on the, well, otherwise, Your Honor, I have a quick question. This is only meant to refresh the witness's recollection. I didn't intend to display it because it's work product we've marked all over it. So when I asked that, may I approach the witness and have it sitting here in front of both of us and ask her about the times if I speak loud?
Right, you don't have to enter it as an exhibit.
Okay, just so long as I can.
And use it to refresh your memory.
And refresh your memory, and actually, I'll need to talk to her about, is this refresh your recollection? And then I can leave it up here with her?
Yes.
Okay, very good.
But make sure you have the other exhibits that you may need.
Yeah.
That's one of the things. Clean. It's not sure.
But I'm talking about the exhibits from 7-11 if you don't have them already.
I got it.
I do have an update as far as that computer is concerned. If you want to take first back, or if it's not important to you,
Well, no, everything's important, but I just want to make sure that it's in conformity to our previous discussion. It is.
okay. All I was saying, why don't you?
I just took a few out. And I took about the ones off of the back.
And if you'll please stand for the jury. seats. And with the state having rested its case, the defendant's case will now proceed. Detective Paulus, good morning. Let me ask you, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of law?
I do.
Thank you. Go ahead and take your seat. Come up to the microphone and adjust it to whatever level you need. Why don't you begin this morning by, again, giving us your full and complete name, the spelling of your last name, and with whom you're currently affiliated.
My name is Irma Palos. My last name is spelled P as in Paul, A-L-O-S, and I'm employed by the Las Cruces Police Department, and I'm assigned to the Detective Division.
Thank you. Mr. Clark, you can commence with the direct examination of Detective Paulus.
Thank you, sir. Detective Paulus, why don't we start out by you telling the jury how long you've been a police officer, and most particularly how long you've been a detective.
Yes, sir. I graduated from the Las Cruces Police Academy in 1999. I have been with the police department a little over 16 years. I started off as a patrol officer for approximately 7 years, and after that I became part of the detective division, so I have been detective for close to 9 years now.
All right. And as detective, what are your jobs? What's your job description as a detective? It kind of sounds like a silly question, but go ahead and lay it out there.
As a detective, we are called out on different types of calls. It can range from child abuse to a burglary to home invasion, homicides, deaths, elderly abuse, and we are called out to investigate those incidents.
All right. And in order to become a police officer for the Las Cruces Police Department, you had to undergo the Las Cruces Academy, Police Academy?
Yes, sir.
Okay. And did you successfully complete that academy, first shot out of the first try?
Yes, sir.
Okay. And how many homicide investigations had you been assigned to as lead case agent as of the date of the shooting back to almost 2 years, 18 months ago?
I have assisted on many, but assigned as a case agent, I've been assigned one other homicide.
Okay. And I think will you agree with me, or is the case agent, is their responsibility to oversee the investigation?
Yes, it is.
Is that a fair representation of your job in this case?
Yes, sir, it is.
And would overseeing the investigation include evidence collection?
Correct.
Making sure that things are sent to the lab to be tested?
Yes, sir.
Coordinating witness statements?
Yes, sir.
Making sure that paperwork is completed in a timely manner by other officers?
Yes, sir.
You are, well, correct me if I'm wrong, but is it true that the case agent is the boss in charge of this case?
I am. Yes, I am.
All right. So is it also a fair statement that the buck would stop with you?
Yes, sir.
Okay. And when people have questions about what they're to do, would they come to you to ask?
Correct.
And would you give out job assignments?
Yes, sir.
For instance, if something needed to be done at the hotel, you can delegate or designate a person to do that, right?
Yes, sir.
Okay. And if something needed to be sent to the crime lab, that would be you, or could you designate that as well?
I could designate it, but it was me
Okay.
in this case.
And when communications are going back and forth between DPS, the Department of Public Safety, they would generally be to you as the case agent, correct?
Correct.
And so if the firearm and tool mark section needed additional information, they would be emailing you or communicating you or calling you on the phone, right?
Yes, sir.
Okay. And in fact, those communications did take place in this case, right? There were,
Yes, he did.
were there questions being asked from certain divisions of DPS, and you would respond about what you wanted done, right?
Correct.
Okay. Now, being the case agent also requires, does it not, testimony on occasion, right?
Yes, sir.
Okay. And when this case first got started, you were asked to testify before the grand jury, were you not?
Yes, sir.
Okay. And let's talk for a moment, if we will, if we can, about your job as the case agent and testifying, right?
Correct.
Okay. Presumably you're going to know what statements have been made by different people, right?
Correct.
And presumably you're going to know what, if anything, a defendant has said in relationship to statements or statements either against him or for him, right?
Correct.
Okay. And when you are preparing for a grand jury, you know you're testifying under oath, right?
Correct.
Okay. And it's real important to test when you're testifying at the grand jury to give the grand jury all the facts, right?
Yes, sir.
Because you're under oath and you know, and will you agree with it? One of your duties as a police officer is to try to make sure justice gets done, right?
Yes, sir.
Objection, Your Honor, to this continued pattern. I understand it's the court's instruction, but
Now, at this point, the court is going to overrule the objection. Go ahead and proceed.
And one of the things about the grand jury is it's an investigative body, right?
Excuse me?
The grand jury is an investigative body, right?
Correct.
All right. And for people who are a little unfamiliar with the grand jury system, you are offering testimony to a group of people to determine whether they're going to be charges, right?
Correct.
And so you know from not only your training and your experience that it's important to get as much information to the grand jury so they can make an informed decision, right?
Yes, sir.
Yeah. And you testified at the grand jury in this case, right?
Correct.
And you were under oath, right?
Yes, sir.
Sworn to tell the truth, right?
Correct.
And embodied with the knowledge that you needed to give all the information you had to the grand jurors, right?
Yes.
So they could make an informed decision about charges in this case, right?
Yes, sir.
Okay. And you remember that testimony to the grand jury, don't you?
I don't recall.
If you had the opportunity to review the portions of the grand jury transcript, would that refresh your recollection before
Yes,
I ask
sir.
you some questions? When I approach the witness, Judge.
Although, Mr. Clark, do you wish to ask a specific question?
I can, if that speaks.
She may be able to respond to
Sure, I can. Do you remember, being asked at the grand jury by one of the grand jurors if Mr. Chan had made any statements regarding self-defense?
I do not recall that.
Okay, so specifically at this point?
Yes.
Okay. May I approach with you?
Yes, go ahead.
And I'm looking at page 19-ish. Okay. So starting on page 19 and then through 20. You could read the bottom of 19 through 20. You don't have the transcript?
Yes, sir.
Your Honor, for the record, Mr. Rourke's just taking a look at it. So, Detective, does that kind of refresh your recollection about this grand jury proceeding that was such a long time ago?
Yes, sir.
Okay. So you'll agree with me that during the course of that grand jury testimony, one of the grand jurors, who's a person in the grand jury, not law enforcement, right?
Correct.
Not somebody from the DA's office, not a judge. It's a person in the grand jury, right?
Correct.
They ask you specifically, and I think the language is, I'm wondering if at one point or another it could have been self-defense gone wrong. And Mr. Byers says, let me add some questions because the way the question you pose right now, we're not able to deal with it. And is the and Mr. Byers asks you this question, is the Las Cruces Police Department aware of any statement made by Target Chan, other of which that have been provided by the grand jury so far, right? You remember that question?
Yes, sir.
And your answer is no other statements, right?
Correct.
And you knew that Mr. Chan had said, he shot at me first, I did this in self-defense, I did what I had to do, he was going to kill me, I had to put him down, right?
Yes, sir.
And you knew you were sworn to tell the truth, right?
Correct.
And you knew that that was a pretty basic question, right?
Yes, sir.
Yet, in spite of all this knowledge, isn't it true that you said, nope, no other statements?
That is what my statement says. Yes, sir.
And you were under oath at the time, right?
Yes, sir.
And was there ever an effort to go back and change that sworn testimony to the grand jury?
No, sir.
Did you ever go back later and say, oops, made a mistake. I remember that Ty told me it was self-defense, right? You never did that?
No, sir.
There was no proceeding to go back and modify your testimony, right?
Excuse me?
You never took any steps to modify this testimony?
No, sir.
You never took any steps to alert Mr. Byers, who was presenting at that grand jury, that you'd made a mistake?
No, sir.
In fact, there were no remedial steps whatsoever. You just let it ride, knowing that was false, right?
Yes, sir.
That's perjury, is it not?
I do.
You're asking for a legal conclusion, that's all.
You were sworn to tell the truth,
Correct.
and you gave a statement to the grand jury that was not truthful, correct?
I stated that there was no statement from Mr. Tai Chan. I did read the transcript that you handed me, but when I answered that question, I was stating that there was no statement made to him when his Miranda was read.
That's not what your answer is that I read to you, right?
Excuse me?
That's not, the question I asked you had nothing to do with Miranda. is it?
Objection, Your Honor. Argument.
Not in the form that it's in. Of course, we overrule the objection.
What I read to you in the answer you gave, that gave no qualification about Miranda, did it?
That's correct.
Okay. All right. Now, as far as evidence collection goes, as the kind of the boss of the case, right?
Correct.
You're the person who's in charge of sending things off to the lab, right?
Yes, sir, I am.
And making sure that everything of evidentiary value that needs to be tested gets tested, right?
Yes, sir.
And whether it's a pistol or whether it's a projectile or whether it's a bloody knife, I mean, whatever the case may be, that's on you to get it tested, right?
Yes, it is.
Okay. And we've seen a photograph, and I'm going to show you the photograph. There we go. Now, we've seen a photograph, and this is marked for identification as Defendant's 52. You recognize that photograph, right?
Yes, I do.
Okay, and we've seen this before, but you can see the evidence cone there, the evidence marker H, right?
Correct.
Okay, evidence marker H, it's been determined that evidence marker H was packaged, there were multiple items of evidence in evidence marker H, right?
Correct.
All right, and the evidence included the blanket, right?
Correct.
And the blanket is the part on top that has all that blood on it, right?
Yes, sir.
And then the sheet, which the DNA expert testified the other day about, was underneath, right?
Correct.
And the sheet also had blood on it, correct?
Yes, sir.
Okay. And then, and those were all packaged together, right? As item H.
They were packaged separately in bags.
But it was all item H.
Yes, sir.
Okay. And when we found out what had been tested at the lab, we found out that only the sheet that was underneath had been tested at the lab, right?
That is correct.
And we know from the learned testimony of the woman from the lab that the blood on that sheet belonged to Tai Chan, right?
Yes.
Okay. Now, and that was, you got that report back in your office on February 4th of 2015, right?
Yes, sir.
Okay, so within, let's see, October, November, December, January, so about 4 months after the incident, right?
Correct.
And there was no other testing done on the blanket for many, 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 many months, right?
Yes.
Okay. Now, there's one or two questions that, and the first question is, you're going to test everything you believe to have evidentiary value, right?
Yes, sir.
And you're going to make sure that every conceivable item that you think is important to the case, that contains blood, or is a weapon, or a projectile, anything of evidentiary value, you're going to want to test that, right?
Correct.
Okay? And so, am I to understand that you believe that this blanket, the top one, had no evidentiary value for all of these months.
No, sir.
You didn't think it had any evidentiary value?
Oh, I misunderstood your question. Yes, it did.
It did.
Yes,
Now,
sir.
you'll agree with me that it wasn't sent off in February or March or even all of 2015, right?
That's correct.
It wasn't sent off for testing in all of 2016, right?
Correct.
It was actually sent for testing on June 1st, right?
Correct.
And it was sent for testing after the DNA analyst said, there's blood on the sheet, but I didn't test the blanket because it was never sent to me, right?
That is correct.
Okay. Whose fault is it that it was never sent to her?
That is my fault. I am the case agent.
Okay. And when did you discover this oversight on the blanket? When did you discover that there had been this oversight in not sending this blanket for testing?
On June 1st, when I was sitting here in the courtroom.
And so there was some scrambling around to take remedial action, right? Like you wanted to get that tested, right?
Well, I wouldn't say it was scrambling around, but I was told to send it off to get it tested.
Okay. And as a result of the actions to have that tested, we are fortunate to have the results back on that blanket, right?
Correct.
Yeah, because there was this lingering question about, well, we know Tai Chan's blood is on the pillowcases and Jeremy Martin's blood is not, right?
Correct.
And we know Tai Chan's blood is on the sheet and we know Jeremy Martin's blood is not, right?
Correct.
But we were left with this hanging question about whose blood this is on the comforter, right?
Correct.
But we know the answer to that now, don't we?
Yes, sir.
Yeah, because the lab tested it and all of the blood on the comforter, on the blanket, belongs to Tai Chan, correct?
Yes, sir.
That is not in question any longer, is it?
No, sir.
And we have the report,
Yes, we do.
and you reviewed the report,
Briefly, yes.
and you have no reason to believe that the examiner made any mistakes?
No, sir.
And so it is conclusive that Tai Chan's blood is on the cover, on this blanket, and Jeremy Martin's blood is not, right?
Yes, sir.
Thank you. Now, let me ask you about item 53. So look at it states, defendant's 53, that's item F, right?
That's correct.
And item F is the cell phone, which belonged, you later learned, to Tai Chan. Right?
Yes, sir.
And if you look on the floor here, there are some droplets of blood, right?
That is correct.
Okay. And it would have been your job as the lead detective to direct evidence techs or evidence people to collect evidence, right?
Yes, sir.
Okay. And you'll agree with me that, none of those droplets were ever tested for DNA, right?
Yes.
They were or weren't?
No, I agree with you.
Okay. And again, there are a variety of reasons why something isn't tested, and we've already established that everything of evidentiary value you want tested, right?
Correct.
But I guess the presumption, and you can correct me if I'm wrong, but the presumption was there's so much of Tai Chan's blood here that this must be Tai Chan's blood, so we shouldn't even test it.
Are you asking me to explain to you? Or
Well, no, I'm asking that you either think it has evidentiary value or you don't, right?
Correct.
And so this must not have had much evidentiary value in your mind, or of course you would have tested it because that's your job and that's what you want to do and that's why you want to be a good case agent, right?
The blood droppings on the carpet were not swabbed, so therefore they were not sent out for testing.
And they weren't, and presumably they weren't sent for testing and weren't swabbed because it didn't really seem of much evidentiary value to you.
Jason, Your Honor, ask and answer.
Sustained. Another question?
Okay. All right. When did you first arrive in the hotel room 711?
I arrived at Hotel Encanto a little after midnight, probably around 2 a.m., 2:20
Okay. On the evening of the shooting, right?
on the morning of the shooting.
I'm sorry. The shooting happened somewhere around 12:20, perhaps, and so you get there about 2?
Correct.
Okay. And had the warrant been executed yet? Had evidence techs begun to collect evidence?
No, sir.
All right. So when you get there, it's in its, I can't say pristine state, but it's in its original state, and it hadn't been disturbed, right?
Correct.
And so you were able to take a look around, and you made some observations, and some things about the state of the room led you to make some conclusions regarding at least some things that had happened in that room, right?
I did not make any conclusions at that time.
Well, you made the conclusion, I believe, did you not, that there had been a struggle in the room? When you were interviewed by law enforcement officers, didn't you indicate to them that you believed there had been a struggle in the room?
I'll allow a question. Okay. Go ahead and respond.
Didn't you believe there had been a struggle in the room?
Yes, sir.
Okay. And that was based on kind of the state of the room, pillows thrown on the floor, some shoes around, some clothes around, of course the blood in various places, right?
Yes, sir.
And then the bullet mark in the ceiling and the one in the door.
Correct.
And that was your opinion that there had been a struggle in the room was based on your years as a police officer, right?
Yes, sir.
And you weren't at that point in time prejudging who had done what. It was just, this is my perception that there had been a struggle in this room, right?
Correct.
Okay. And when you made these observations about the struggle in the room, you didn't know whose blood was on the bed, right?
I did not.
Okay. And you had not been made aware that Mr. Chan was making statements that it was in self-defense, right?
No, I had not.
Okay. So when you see the struggle in the room, you hadn't made any sort of prejudgments or predeterminations about who had shot who was guilty, who was innocent, right?
No, I had not.
Okay. Then you began collecting evidence, or began overseeing the collection of evidence, right?
Correct.
And ultimately the determination was made to charge Mr. Chan with murder, right?
Correct.
Okay. But the ultimate decision to charge Mr. Chan with murder was made long before, months before you had the DNA results back on the blood on the bed, right?
That is correct.
And the decision to arrest Mr. Chan for first-degree murder was made long before you had any DNA results on the firearm, right?
That's correct.
Okay. And as far as you're concerned, you received both of these pieces of information about DNA on the gun and DNA on the bed, the blood, after you testified at grand jury, right?
Correct.
And will you agree with me that once someone's been charged, once the decision to make some charge of somebody with first-degree murder has been made, it's hard to walk back from that decision, isn't it?
Correct.
Yeah, so once the decision has been made to charge somebody with first-degree murder, no matter what information you find out down the road, it's Ty's blood on the bed, there's a mixture of DNA on the gun, it's hard to stop that train rolling against somebody who's already been charged with murder, right?
Yes, sir.
Yeah. Even if you had second doubts, or even if you had thoughts that, well, maybe this didn't go down like I originally thought it went down, it's still hard to stop the momentum moving against the defendant, right?
Correct.
Okay. Even if you wanted to.
Correct.
Now, the DNA that was recovered from the firearm, do you know when you got that report back?
I do not recall the date.
Okay, but most certainly it was after you testified at grand jury, but during the course of your investigation and prior, of course, to the start of the trial, right?
Yes, sir.
That fact has not been the fact that there appear to be, at least on the DNA results, multiple contributors to the DNA on the gun. That's been a fact known to everyone for a long time, right?
Yes, sir.
Okay, and the only gun that got sent for testing, and please correct me if I'm wrong, the only gun that got sent for testing was Ty's gun, right?
Yes, sir.
And there were two other guns found at the scene, right?
Correct.
And they were, and I'll show you the photograph of it. This is that Springfield XP, which belonged to Jeremy Martin. You recognize that?
Yes, sir.
Okay. And then, let me show you the other one. And then the other one, although it's a little more obscure, I'm showing you the state's 235. The Glock is in this holster, right?
Correct.
Okay. Now, and the Glock I'm referring to is Jeremy Martin's service weapon, right?
Yes, sir.
And Jeremy Martin's service weapon is the identical gun, or it's same model, same manufacturer. It's a Glock 357, same model, right?
Correct.
Same magazine style.
Correct.
The only difference is it doesn't have a flashlight lug, right?
Yes, sir.
But the mechanism for firing are the same.
Correct.
I mean, it's the same pistol, sans the flashlight lug, right?
Yes, sir.
All right. And that gun, if I'm not mistaken, even though it is identical in manufacture and make to Jeremy Martin's gun, never was sent for any kind of testing, right?
No, sir, it was not.
And not only was it not sent for comparisons to the projectiles, it wasn't sent for any purpose to see if it had been fired, to determine whether any of the shell casings matched, nothing, right?
Correct.
Okay. And one of the things you learned very early in this case, perhaps even on the night of the shooting, was when Ty is telling the officers, I did this in self-defense, Mr. Martin shot at me first, right?
I did not learn that till later.
Okay. But certainly you learned it before the trial, right?
Yes, sir.
And you certainly learned it many, many months ago, right?
Yes, sir.
And you certainly learned it while the investigation was still fresh, within a few days, right?
Correct.
All right. Now, one of the things that happens when somebody dies, generally speaking, I think it happened in this case, is their hands are bagged, are they not?
Yes, sir.
And in this case, would have been no different, right?
Correct.
Mr. Martin's hands would have been bagged, and that's to preserve evidence, right?
Correct.
Because as a police detective who has experience in all kinds of crimes over 19 years, you know that the evidence can be recovered from the hands, right?
Correct.
Oftentimes, fingers and fingernails are a great source of DNA. That can be a rich source of DNA, right?
Yes, sir.
And you saw photographs and you knew that Mr. Chan had some scrapes and scratches, right?
I did not see those till later.
Okay, but not much later, maybe a few days?
Yes, sir.
Okay. And so you knew while Mr. Chan's injuries didn't appear to be life-threatening, like the scratches and such, you knew that he had scratches on his body, right?
That is correct.
And knowing that the fingernails are rich sources of DNA and knowing that those photographs resemble perhaps scratch marks, one would certainly be interested in checking Jeremy Martin's hands for DNA, right?
Correct.
Okay. And that's the reason you bag the hands, right?
Correct.
And I'm not trying to be insensitive here, but this is the process in any case involving a decedent, right? Or most cases involving decedents whose hands are intact, right?
Yes, sir.
Because you don't want anything to get lost, right?
Correct.
And when they're washing the body, maybe you don't want things to get washed away that could contain evidence which could be either helpful or hurtful to your case, right?
Correct.
Because it's not your job just to collect the good stuff for the police and get rid of the bad stuff, right?
Correct.
Because your job is to do justice.
Yes, sir.
And your job is to investigate and make sure that your charging decision is correct, right?
Yes, sir.
Because you want to make sure potentially a jury like this gets all the facts.
Yes, sir.
All right, so given that kind of groundwork, and Mr. Martin's hands were bagged, and you saw some bruising on his knuckles, right?
Correct. Excuse me, I never responded to Mountain View Hospital. I did see the photos of Mr. Martin, but I did not see him in person.
And the photographs you saw, again, fairly contemporaneous, within a few days of the shooting?
Correct.
And so you knew that Mr. Martin had some bruising on his hands, which certainly in your line of work is consistent with blunt force trauma, right?
Yes, it can be.
And whether that blunt force trauma is banging your hand on a wall because you're angry or punching somebody in the head or face, that's all blunt force trauma, right?
Correct.
And you might not know what the blunt force trauma was from, but you had evidence that Mr. Chan had been struck in the nose and mouth, right?
Yes.
And you had evidence that Jeremy Martin had bruising on his hands, right?
Correct.
And so certainly your deductive reasoning would lead you to the conclusion that maybe these hands could hold evidentiary value, right?
Yes, sir.
All right. And so when you're going down your checklist of things you might do, one of the things that could have been done is swab Jeremy Martin's hands for DNA, right?
Correct.
Because one of the things that could have shown us, we don't know because it didn't get done, right?
Correct.
But one of the things that could have shown us is the presence of blood, maybe, right? or the presence of any kind of DNA on Jeremy Martin's hands, right?
Yes, sir.
It could have. We don't know because it didn't get done, but it could have, right?
Yes, sir.
All right. The other thing that you have at your disposal, which is an important piece of evidentiary, well, it's an important tool for your investigatory tool bag, I guess, is the ability to see if someone has fired a handgun, right?
Correct.
All right. And that's the other reason you're going to bag somebody's hands, right? So maybe chemicals don't get washed away that could tell us whether somebody's used a handgun recently or not, right?
Correct.
And even though it might not have been that night, even though it might not have been even the next day, within a few days, you certainly learned that Tai Chan was claiming that Jeremy Martin shot at me first, right?
Correct.
And the claim, and that claim was in conjunction with, I had to do this, it was a self-defense, right?
Yes, sir.
Okay, and we've already established that you have a test, and it's just a swab test, right, where you take a Q-tip, and you swab it, and you put it in a container that's sterile, and you send it off to be tested, right?
That's correct.
Because when, we learned during the course of the trial that when a firearm is discharged, there's gases are expelled both from the muzzle and from the ejector port, right?
Correct.
And so if I shoot a handgun, there may be deposits of unfired gunpowder, of different variety of chemicals when I shoot a gun, right?
Objection, Your Honor. Counsel has been testifying.
At this point, it should be a little bit less.
Yes, sir.
Actually, let me interrupt you. We're already a little bit past the noon hour. Yesterday was a exceptional circumstance that we went through the noon hour. I'm going to give the jury and our staff and everyone else a break. I apologize for interrupting your direct examination, but we'll resume at 1:45 this afternoon.
Not a problem.
So we're in recess until 1:45.